Stop! New USCIS Form I-129 edition. Starts April 1st, 2026. Avoid automatic rejections. The envelope was sealed. The filing fee was paid. The attorney had reviewed the documents 3 times. The package was ready to go out the door. And then someone checked the USCIS website, and everything stopped. Because starting April 1st, 2026, USCIS will only accept a new edition of Form I-129, the petition for a non-immigrant worker, not the version filed last month, not the version that has been used for the past year, a new edition, and any I-129 package submitted on or after April 1st using the old edition will be rejected, not delayed, not returned with a correction notice, rejected, automatically, without review, without refund in many cases. That rejection could mean a worker loses their status. It could mean a visa extension fails. It could mean an H-1B, an O-1, a TN, an L-1, gone, because of one wrong number printed at the bottom corner of a form. Most employers, most HR teams, and even some attorneys are going to miss this. They are going to keep using the form they have saved on their desktop, the one that has always worked, the one that looks almost identical to the new one, and they are going to fall straight into this trap. But today, you are going to do something different. For months now, there had been signals, not from major immigration news outlets, not from employer HR bulletins, just signals, that USCIS was preparing a significant update to one of the most widely used non-immigrant petition forms in the entire system. Form I-129 is not a niche document. It is the form that drives the majority of temporary work visa petitions in the United States. H-1B specialty occupation workers, L-1 intracompany transferees, O-1 individuals with extraordinary ability, TN professionals under the US-Mexico-Canada Agreement, E-3 Australian specialty occupation workers, H-2A agricultural workers, H-2B seasonal non-immigrant workers, H-3 trainees, R-1 religious workers, all of them, their petitions, their extensions, their changes of employer, flow through Form I-129. This is not a form used by a few hundred people a year. This is a form filed hundreds of thousands of times annually by employers across every industry in the country. And USCIS has updated it. Immigration practitioners who monitor USCIS form revision cycles, recognize how these updates work. The agency quietly posts a new edition number at the bottom of the form. The edition date changes, usually in small print, usually in the footer. A grace period is sometimes granted during which both old and new editions are accepted. And then the grace period ends. And then the old edition becomes a rejection trigger. What made this particular revision command attention was the timing. April 1st, no grace period extending into summer. A hard cutoff date that lands at the start of a new quarter. And critically, right in the middle of H-1B cap season activity and petition preparation cycles. Earlier this year, USCIS posted the updated edition of Form I-129 on its official website. The new edition carries a revised edition date that distinguishes it from all prior versions. That edition date is printed at the bottom left corner of every page of the form. It is the detail that will determine whether your petition package is accepted or rejected on April 1st. USCIS has been explicit. Starting April 1st, 2026, they will only accept the new edition. Any package submitted using a prior edition on or after that date will be automatically rejected at the lockbox, the intake facility where petitions are received and initially processed before being forwarded to the relevant service center. The lockbox does not review the substance of your petition. It does not look at your supporting documents. It does not evaluate your legal arguments. It checks form additions. It checks fees. It checks basic submission requirements. And if the form addition is wrong, the package goes back. The word USCIS uses is reject, not deny. The distinction matters legally, but in practical terms, for a worker whose H-1B extension was submitted on the wrong form one day before status expiration, the distinction provides very little comfort. The urgency here is not symbolic, it is structural. Think about who files Form I-129 and when. H-1B extensions are often filed close to the worker's current status expiration date. Employers who wait until the last few weeks before a status expires, which is more common than it should be, are the most vulnerable to this change. If an attorney prepares a full H-1B extension package using the old I-129 edition in late March, and the employer's HR team sits on it for a week before authorizing the filing, that package could arrive at the USCIS lockbox on April 2nd. Wrong edition. Automatic rejection. Now the worker's status has expired. Now the employer needs to refile with the correct form, new fees, new preparation time, while the employee is technically out of status. Out of status is not a minor inconvenience in today's enforcement environment. Out of status creates vulnerability. It creates bars to certain immigration benefits. It can complicate future visa applications. And it happens because of a form addition date that no one checked. Let me walk through exactly what you need to do right now if you have any pending or upcoming I-129 filings. Step 1. Go to uscis.gov directly. Navigate to the Forms page. Find Form I-129. Download the current edition from the official USCIS website today. Do not use the version saved on your computer from a previous filing. Do not use a version your attorney sent you 2 months ago without confirming it has been updated. Do not use a version downloaded from any third-party website. Download directly from uscis.gov. The edition date is printed at the bottom left corner of the form. It will also appear in the form instructions and on the USCIS Forms page listing. Confirm that the edition date on the form you are using matches the edition date listed as current and required on the USCIS website. That confirmation takes less than 2 minutes, and it is the difference between a processed petition and a rejected one. Step 2. Audit every pending I-129 that has been prepared but not yet filed. If your law firm, your HR team, or your immigration vendor has prepared I-129 packages that are in queue waiting for employer signatures, attorney review, or payment authorization, every single one of those packages needs to be checked against the new edition requirement before submission. If the I-129 in those packages is the old edition, the entire form needs to be redone using the new edition. This is not optional. This is not a matter of attaching a note explaining that the old form was used in good faith. USCIS has published the mandatory edition date and the mandatory effective date. There is no good faith exception at the lockbox. The form is wrong or it is right. Step 3. Communicate this to every stakeholder involved in your immigration filings. If you are an HR professional managing a workforce of H-1B workers, your immigration counsel should already be aware of this change. If they have not communicated it to you proactively, ask them directly today. If you are a worker whose extension or change of employer is being prepared by your company's immigration team, ask your HR contact or your immigration attorney to confirm which edition of the I-129 is being used in your package. You have the right to ask that question. Your status depends on the answer. There is a specific population that needs to pay particularly close attention to this deadline. Workers whose current H-1B status expires in April, May, or June of 2026. If your status expires within the next 90 days and your extension petition has not been filed yet, your attorney or employer needs to be using the new edition right now. Extensions filed under the cap-gap rule, where an H-1B worker's status is maintained while an extension is pending, depend on the petition being properly filed. A rejected petition does not create cap-gap protection. A rejected petition does not toll the worker's status. If the petition is rejected and refiled after the status expiration date, the worker may have a gap in status that creates complications for future immigration benefits and for travel. This is the scenario that keeps immigration attorneys up at night during form transition periods, and it is entirely preventable by checking one date on one form before mailing the package. Now let me address the other non-immigrant categories filed on Form I-129, because the H-1B focus sometimes overshadows the fact that this form is used broadly. O-1 petitions for individuals with extraordinary ability in sciences, arts, education, business, or athletics, filed on I-129. L-1A and L-1B petitions for intracompany managers, executives, and specialized knowledge workers, filed on I-129. TN petitions for Canadian and Mexican professionals under the USMCA, filed on I-129 when filed with USCIS rather than at the port of entry. E3 petitions for Australian specialty occupation workers, filed on I-129. H-2A agricultural worker petitions, filed on I-129. H-2B temporary non-agricultural worker petitions, filed on I-129. Every employer, every attorney, every HR professional handling any of these categories has the same April 1st deadline. Every pending package in any of these categories needs the same addition check. The form is universal. The deadline is universal. The rejection risk is universal. There is also a practical dimension to this that goes beyond individual petitions. Large employers who manage high volumes of immigration filings, technology companies, healthcare systems, research universities, staffing agencies often use immigration software platforms or vendor systems to generate and manage I-129 packages. Those platforms need to be updated to reflect the new edition. If a platform vendor has not yet pushed an update to their form templates, the packages generated through that platform may still be generating old edition forms. If you are an HR professional who relies on a software platform for your immigration filings, contact your vendor today and confirm that their I-129 template has been updated to the required new edition. Do not assume the update happened automatically. Do not assume your vendor is ahead of this. Confirm it in writing. The employer is ultimately responsible for the accuracy of the petition package, not the software vendor. A rejection caused by a vendor's failure to update their template is still a rejection on your worker's case. Let me also address what happens if a petition is rejected under this rule. USCIS will return the package with a rejection notice explaining the reason. The employer must then refile using the correct form edition with the correct filing fees. Whether the original fees are refunded depends on the specific circumstances. USCIS has policies around rejected versus denied filings, but in many rejection scenarios, fees are not automatically returned. The time cost of a rejection is significant. Preparing and resubmitting a complete I-129 package typically requires attorney time, employer review, and logistical coordination that can take days to weeks, depending on the employer's internal processes. For a worker whose status is expiring, that delay window is not just inconvenient, it is potentially status-threatening. And for employers who operate under tight compliance standards, a rejection on record creates documentation that their immigration processes have weaknesses, documentation that can matter in audits, in Department of Labor investigations, and in other compliance contexts. The stakes extend well beyond a single rejected envelope. As April 1st approaches, more employers and attorneys will begin communicating about this change. The information will spread, but it will not spread fast enough for everyone. There are employers right now who have I-129 packages prepared and waiting to be mailed in the next 2 to 3 weeks. There are workers right now whose extensions are being processed by HR teams who have not yet been briefed on the edition change. There are attorneys at smaller firms managing high caseloads who may not catch this in time for every client. The window between now and April 1st is narrow. It is the kind of window that separates the families who act from the families who wonder what happened. Knowing this right now does not make you a burden on the system. It makes you someone who understands how the system works. It means you can protect your status. It means you can protect your family's stability. Go to uscis.gov right now and download the current edition of Form I-129. If you have a pending petition, call your attorney today. If you manage immigration for employees, audit your queue today. If you are an H-1B worker whose extension has not been filed, ask about the form edition today. Share this video with every employer, every HR contact, every immigrant worker you know who is in the H-1B, L-1, O-1, or TN pipeline. One conversation today could prevent a rejection that takes months to recover from. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.